Good afternoon, ladies and gentlemen, and welcome again to another edition of our AHI Virtual Speakers Forum. As always, we are broadcasting live from our American Hellenic Institute headquarters in Washington, D.C. Hellenic House. My name is Nick Larigakis. I'm president of the American Hellenic Institute, and it is once again my pleasure to welcome you to one of our discussions. As we've mentioned, we have dedicated the month of July to presentations on Cyprus and the various facets that have occurred over the years due to the illegal invasion of Cyprus by Turkey in '74. And today's discussion will highlight one of these different elements that have come to fruition, unfortunately, over the course of the last couple of years, and that's the economic zone and the violation of the economic zone of Cyprus. Therefore, our title today is Cyprus Exclusive Economic Zone, Law of the Sea, and Turkey's Maritime Claims. And we have, as always, special guests who are keenly aware of the issue, and we look forward to their presentation in a few minutes. They are, of course, Ambassador Andrew Jacovides and Nicholas Karambelas, our AHI Board of Directors and Legal Counsel. And when I introduce them, I'll speak a little bit more about them. Unfortunately, also today is an inauspicious commemoration, if you will, because on this day, on July 15th, 1974, a coup was instigated by the Greek military junta, led by then Colonel Ioannidis, which toppled the then Cyprus president, Archbishop Makarios. The coup, unfortunately, was used as a pretext by Turkey, which invaded Cyprus 5 days later, which resulted in the occupation of 37% of the island territory. Of course, that's for another day, but that was the beginning that led to the developments of which we are here today discussing. A little bit of background, as always. Turkey has had numerous incursions into Cyprus's exclusive economic zone, or EEZ, including conducting illegal drilling in Cyprus's EEZ on 3 different occasions in 2019. These were drilling operations that were supported by Turkish warships and drones. Let's be clear, Turkey is conducting a dangerous gunboat diplomacy in Cyprus's EEZ, so much so that it led to President of the Republic of Cyprus, Nikos Anastasiadis, to decry Turkey's actions and to call it a, quote, second invasion, end quote, and a violation of international law. Turkey has been so brass as to engage with research vessels of U.S. allies in Cypriot waters. Turkey engaged with an Israeli research ship and deported it out of Cypriot waters in December 2019. And in 2018, Turkish warships harassed the surveying vessel of the Italian oil company ENI and threatened to sink it in the exclusive economic zone of Cyprus. And this year, in April, Turkey sent the Yavuz, a Turkish energy research vessel, to Blocks 6 and 7, which have been licensed to the aforementioned ENI and, of course, the French company Total to explore in Cyprus's exclusive economic zone. The government of Cyprus highlighted the illegality of such an action, and U.S. Ambassador to Cyprus, Judith Garber, condemned the Yavuz's activities as a, quote, provocative step, end quote. The French and Israeli governments, as well as the EU, also spoke out about this most recent action that was taken by Turkey. So today, we will now turn our attention to our experts, because although many of us who hear the term EEZ really do not know what exactly it means and ultimately how it's defined. These are a little bit of alien concepts to, I would say, the laypersons within our community, and we need to bring it a little bit more into focus and to highlight why Cyprus is in the proper side of international law regarding this issue, and why Turkey is not on the proper side of international law, and everything that it conducts within this exclusive economic zone is totally illegal under every definition of international law as it relates to the definition of the EEZ. And for that, we will now begin with an introduction of our first speaker. And to lead us off today is our own Nick Karambelas, who is, as I said, is a board member of the American Atlantic Institute and who serves also as our legal counsel. Nick is an attorney who has been in private practice for more than 40 years. His areas of practice are business organization, e-commerce, and international trade. He is a noted author and lecturer, and he holds a BA from Union College, a JD from Fordham Law School, and a Master's of International Affairs from Columbia University. This man, ladies and gentlemen, I believe sleeps no more than 1 hour a night. It's incredible the kind of things he's able to accomplish, and it is a pleasure to have him here. And Nick, I pass on the Zoom microphone to you.
Thank you, Nick. I just want to say how happy I am every time I present at AHI. Gene Rosides hired me, and my first job in Washington was with AHI. He took a chance on a bumbling young lawyer, and I'm still a bumbling lawyer, but not young. Also, on a personal note, I met the ambassador in July 1979 when I first started at AHI, and he was first credentialed by President Carter. He has been a mentor and a friend over many years. Okay, let me talk a little bit about what we're going to do. As Nick said, we're discussing the Cyprus exclusive economic zone. And in order to discuss it, we have to understand the legal regime that has been set up by the United Nations Law of the Sea, UNCLOS, we refer to it. And because it's within that context, within that legal regime, that all the EEZs in the world are established. So obviously the sea has been vital to humankind for centuries, since time immemorial. The practices of seafarers with respect to usage of the sea developed by custom, just by usage. There came a time, however, when these usages and customs had to be put into a code, a law. And there have been several attempts at codification of these customs over the years. The first one that we're aware of was the Rhodian Law of the Sea, or Rhodian Sea Law, which was written and established around 700 BC. There were various other codes through the classical period, the Hellenistic period, Roman, Byzantine, and right through the Renaissance until modern times. This UNCLOS is, in a sense, a comprehensive gathering of all the prior experiences, all the prior customs into one document. It is massive as treaties go. And what we're going to discuss today is really just a small part of it, the legal regime. It goes into all sorts of areas, anything involving law of the sea. And so this makes it the most significant development in law of the sea. And I would even speculate that it's the most significant in terms of in treaties, in history. So let me just give you a slight background, a brief background on the UNCLOS. It was adopted in 1982. As I said, it's a massive document. It has been ratified by 167 countries. That means that it is in effect observed by 167 countries. And even the few countries that do not, are not ratified or not signatories to it, it is customary international law, which under international law applies to all nations. So it really is, in effect, encompasses all nations. Turkey is not a signatory, nor has it ratified UNCLOS. We, the United States, have signed it. President Clinton signed it, and each president through President Obama have asked the Senate to ratify it because, as you know, our treaties have to be signed by the president and ratified by the Senate to take effect. But each Senate, since Bill Clinton signed it, has refused to ratify it. So we're in a situation of having it signed, but not ratified. But to a large extent, we do observe certainly the legal regimes anyhow. Okay. The legal regime, and as we said, Cyprus is part of, Cyprus's EEZ is part of the legal regime. Let's just start with just a quick map to show how the regimes are set up. Okay, does everybody see this map?
I don't see it, Nick.
Okay.
Well, that's okay. You know, we always have technical issues. There we go.
Okay. Let me get my pointer up, and we'll see how this works. Okay.
You may want to just keep going without the pointer.
Yeah. No. As you can see, the tan area is the land. The tan area is the land. This is as if you're looking at the land from a helicopter. Okay, we're looking at it from up above, and where it says the land, that's the territory. Okay, the first line that we draw is the baseline, and that's that line that you see going around the island and across the bays. That's the baseline. That is the line from which all of the zones that we'll see is measured. Okay, the first zone is the territorial waters, as you can see there. The territorial waters extend out 12 nautical miles. Okay, and that's just like the land. The country has complete autonomy and sovereignty over its territorial waters. The next zone is called a contiguous zone, and that is also 12 nautical miles. But that zone is what we call a legal construct. That means that a nation must declare that as a contiguous zone, and then file or register that demarcation with the United Nations. Okay. The next zone that we'll look at is the Continental Shelf. Okay, and that's a concept that's been around for a while. The Continental Shelf extends from the baseline underwater for as long as the shelf is connected to the land, and it slopes usually until it gets out, let's say out to here in this map, out to the end in this map. And what the adjoining nation, the adjacent nation, has the right to do is to exploit the resources that lie on the seabed, on the bed, and the resources that are below the seabed. That's where the hydrocarbons or whatever, that's where the drilling goes on. But the nation is not able to exploit the resources from the surface down to the seabed, only on the seabed and below. Now, there is an international definition of the width and length and what constitutes a continental shelf. It's too technical to go into here, but suffice it to say that that exists. The newest concept, and this has been brought in by the UNCLOS, is the exclusive economic zone. The exclusive economic zone extends from the baseline, back to the baseline, out 200 nautical miles. It is not dependent on any geographical, geological, geomorphological device of any kind, okay? It's only 200 miles straight out. But what the exclusive zone enables a country to do is to exploit the natural resources from the surface down to the seabed and down through the seabed. So what is it between the surface and the seabed? Fisheries is the best example. And there are parts of the world where the fisheries are more important than hydrocarbons. So that was the whole point of the EEZ, to give nations the ability to exploit that area. Now, the big similarity between a continental shelf and the exclusive zone is a nation does not have sovereignty over those zones, but it has sovereign rights, and those rights are exclusive. So only other nations can certainly transit through those areas, innocent passage, other elements of law of the sea. But if they wanted to, for example, put a pipeline through the continental shelf or the exclusive economic zone, they have to get the permission of the coastal state. Okay, now what happens here? You have your exclusive zone extending out 200 miles. In this example, you see that the continental shelf extends beyond 200 miles, okay? To the extent that the continental shelf extends out 200 miles, they're parallel, okay? So that means that under either regime, the coastal state can exploit the resources from surface down and the seabed down to the subsoil. So they overlap. You can do both. A nation chooses to one or the other. It's a more of a technical matter. But then at 200 miles, the exclusive economic zone ends. If the continental shelf, as in this map, extends out again farther than the 200 miles, the coastal nation can still exploit on the seabed and the subsoil, but it cannot exploit from the surface to the seabed. And that's the major difference between the continental shelf and the exclusive economic zone. Okay. There is another zone that we call the International Seabed. And I only mention here because you're going to be hearing a lot more about this in the coming years. And scientists have discovered modules, types of elements that we don't have on the surface. They're deep, within deep crevices, particularly in the Pacific Ocean. And it takes some very sophisticated, obviously, equipment to be able to get down and exploit those. Well, the UN started an agency to regulate the use of these exploitation of these modules and these other resources. And what happens is there's a treaty that's coming into force about it. And it's really only the bigger nations that are able to go down and exploit. And we're talking about miles down through these cracks and crevices in the ocean. But once those begin to be exploited, and there's a whole regime how they have to be shared by the big countries, we're probably going to forget about hydrocarbons. At least that's what I'm told. And that does not rely on exclusive economic zone, continental shelf, anything like that. It is only it is only by treaty. It's sort of like the treaty on the moon. You know, it says these belong to everybody and nobody. So we'll see how that develops, but it's a very important development in law of the sea. Okay, I'm just going to set up our discussion of Cyprus now. We understand the regime, the legal regime. Cyprus, as the ambassador will show, has complied with that. What I want to do here, this is just a review of geography, just placing where all the players are. There's Cyprus is, of course, the island off the coast of Turkey, and Greece to the west. And as you can see from this map, this is not a very quiet neighborhood. Cyprus has a long history, because of its location, of the transit of empires. The last empire to occupy Cyprus only left, and hasn't really left totally, in 1960, when the Republic of Cyprus was established. Just to give you an example of the size of Cyprus, what we're talking about, this is where Cyprus would fit if it were transposed into the United States. Leesburg to Philadelphia, that's what we're talking about. That's the area that we're talking about. With that, Mr. Ambassador, I turn it over to you.
Oh, you turn it back to me.
Oh, I'm sorry, Nick, of course. Silly me.
Nick, I just need you to try to get these maps off now.
Yeah.
Thank you, Nick. And we look forward to the Q&A portion of our program. And this gives me an opportunity to remind all our listeners to please use the Q&A function at the bottom of your screens and to submit a question. Now it's my distinct pleasure and honor to introduce our next speaker. Ambassador Andrew Jacovides has an extensive experience in the political, legal, and economic fields at both a bilateral and a multilateral level. He has represented Cyprus in numerous conferences, including his participation in major legal law of the sea and law treaties conferences. Ambassador Jacovides received his higher education in law at the University of Cambridge, the Inns of Court, and Harvard Law. He has also been awarded the honorary degree of Doctor of Laws by the University of Indianapolis and the Doctor of Humane Letters by Mount Vernon College. He is an honorary citizen of many American cities, and he has also received major decorations by the governments of Greece and Austria. Ambassador Jacovides has written and lectured extensively at law schools, universities, think tanks, foreign affairs councils, and his publications include articles on UN peacekeeping, the law of the sea, the diplomatic court in Washington, and International Criminal Court. Prior to his retirement, the ambassador was the most senior member of Cyprus Foreign Service, having served as the ambassador to the United States twice for a total of 14 years, and is thus having reached the position of Dean of the Diplomatic Corps here in Washington. He also served as ambassador to Germany, was the permanent secretary of the Ministry of Foreign Affairs, and Cyprus's ambassador, permanent representative to the United Nations. He is currently dividing his time between the United States and Cyprus as an international lawyer and consultant. And I remember very fondly the ambassador when I first started working at the American Atlantic Institute back in the late 80s. And I have to say, Mr. Ambassador, you doesn't look like you've aged one day in all the years that I've known you. It is really a tremendous honor for the American Atlantic Institute to have you with us here today. And I pass on the Zoom platform to you for your comments.
Thank you very much, President Naringakis, for your very generous introduction. I'm really very pleased to be speaking to the American Hellenic Institute, which over the years has done so much for the cause of justice for Cyprus. And may I take this occasion to pay highest tribute to my late friend, Jean Rosidis, who spearheaded this struggle. I also want to thank Nick Karambelas for his generous words. The subject we have in front of us is well chosen and should be of general concern. The more so since 2020 happens to be the 60th anniversary of the Republic of Cyprus. Not only has Turkey since 1974 illegally invaded and occupied a large part of Cyprus, which it still occupies with some 40,000 troops, altering the demographic composition and attempting to Islamize it, ignoring the calls of the international community through numerous UN resolutions, but also attempts to appropriate and exploit a large part of its exclusive economic zone through a blatant act of piracy and gunboat diplomacy. The Republic of Cyprus and its democratic government is recognized and maintains diplomatic relations with all members of the international community except Turkey. It is a member of the United Nations since 1960 and a member of the European Union since 2004. Following the intercommunal disturbances of 1963, the Turkish Cypriot members of the government withdrew. After a full debate of the merits of the Cyprus situation in the UN Security Council, the status of the government was accepted in Security Council Resolution 186 and has remained so ever since. By contrast, the so-called Turkish Republic of Northern Cyprus, TRNC for short, proclaimed by Turkey in 1983 in the illegally occupied area of Cyprus, is recognized by no state in the world other than Turkey. It was declared legally invalid by Security Council Resolution 541 of 1983, and in Security Council Resolution 550, the Security Council, quote, reiterated its call upon all states not to recognize the purported state, unquote, and called again, quote, upon them not to facilitate or in any way assist the aforesaid secessionist entity. The United States, both the administration and Congress, in a joint resolution, strongly condemned the purported secession, and President Reagan held a specially arranged meeting at the White House with President Kyprianou to show support for the Republic of Cyprus. I happened to be the ambassador of Cyprus to Washington at the time, and naturally, I was directly involved. To this day, the United States is instrumental in the non-recognition of the TRNC by any state, including the Islamic states. The Cyprus delegation played an active role in the Law of the Sea Conference, including support for a 12-mile territorial sea. Article 3, Cyprus had declared a 12-mile territorial sea already in 1964. It's support for the creation of the new concept of the exclusive economic zone, about which you'll be hearing more about, for cooperation among states in enclosed and semi-enclosed seas, for effective dispute settlement procedures, for the protection of archaeological objects found at sea, among other topics. But we put great emphasis and played a protagonist role, if I may say, on the regime of islands. Together with other like-minded states, we stressed that no distinction whatsoever should be made between islands and other lands, continental lands, in terms of entitlement to the zones of maritime jurisdiction, the zones which Nick Karambelas described earlier on. Turkey and other like-minded states called for a provision that the entitlement of islands should depend on size, population, geomorphology, and contiguity to the mainland. Even though it still maintains this position, even though the law is clearly the other way. The debate lasted for several sessions and ended through the adoption in the final text of Article 121, which completely vindicated our position. That article in paragraph 2, let me read it again, except as provided in para 3, that is about rocks, the territorial sea, the contiguous zone, the exclusive economic zone, and the continental shelf of an island shall be determined in accordance with the provisions of the convention applicable to other land territory. Thus, there is no question that islands are fully entitled to all zones of maritime jurisdiction. Turkey's view was rejected by the conference. On the basis of Article 121, the Republic of Cyprus proceeded in 2004 to declare its EEZ of 200 nautical miles around the island. And here I would request Nick to show the map of the Cyprus Exclusive Economic Zone. It also proceeded to conclude delimitation agreements with 3 of its neighboring states, that is to say, Egypt in 2003, Lebanon in 2007, as yet unratified, and Israel in 2010. These were model agreements on the basis of the median equidistance line and with a provision for arbitration in case of potential disputes. I don't see those on this map. I believe there is another map showing the delimitation agreements with these 3 states. Turkey, which declared EEZ in the Black Sea and delimited it with neighbors there on the basis of the median line, unilaterally and arbitrarily declared a large part of the Eastern Mediterranean. Again, I would request Nick to show the map. There it is. The all red is the area claimed by Turkey. Unilaterally and arbitrarily, I said, declared a large part of the Eastern Mediterranean as its continental shelf, largely encroaching on the Cyprus EEZ to the north, to the west, and to the southwest. Moreover, in September 2011, Turkey and the TRNC purported to conclude a continental shelf delimitation agreement in the north coast of Cyprus, one-sided in favor of Turkey. Turkey got 2/3 and the TRNC supposedly got 1/3. Needless to say, such delimitation agreement has no status in international law, being between the occupying power and its dependent creation, condemned as an illegal entity and determined to be so not only by the Security Council in the resolutions I cited earlier, but also by the European Court of Human Rights in the Loizidou case. The Cyprus government proceeded to number several blocks in its EEZ to the south as delimited with Egypt and concluded agreements for their drilling and exploitation with a number of major international oil companies, including ExxonMobil and Noble American, Total French, and Eni Italian. A number of such drillings have taken place with substantial results, but at present, because of the pandemic and the low price of oil and gas, they are suspended until next year. Turkey ignored the Cyprus exploration contracts and proceeded to illegally drill there, partly on the claim that such activities are in its own continental shelf, and partly on the basis of quote unquote licenses by the so-called TRNC. There can be no doubt that such licenses are invalid, as the TRNC itself is legally invalid. It would be unprecedented and even absurd for a community, as the Turkish Cypriots are, to give such licenses. In Cyprus, as in any other country in the world, the reserves in the EEZ belong to the recognized government and not to any community or minority. For example, you do not see the Maronites in Lebanon, or the Copts in Turkey, in Egypt, or the Muslims in India, or indeed the Kurds in Turkey to have such a claim. The Turkish Cypriots, as Cypriot citizens, will benefit from the EEZ resources of Cyprus, as any other Cypriot citizens, be they Greek Cypriot or Armenian or Maronites or Latins, within the context of a Cyprus settlement. Even in the absence of such a settlement, ways have been proposed to allocate a percentage of the proceeds of the EEZ reserves to the Turkish Cypriot community. The claim of Turkey that a large part of the Cyprus EEZ, as defined by the median line and Article 121, belongs to Turkey's continental shelf, unreasonable though it is, can be dealt with by negotiations on the basis of international law as provided in Article 74 of UNCLOS, leading to agreement or judicial settlement. The Cyprus foreign minister repeatedly made such proposal. Indeed, it was very recently also suggested by Commissioner Borrell of the EU, but Turkey refused, since they say Turkey does not recognize the Republic of Cyprus. In so doing, Turkey is in a minority of one. Indeed, under the Ankara Protocol of 2006, Turkey is under an obligation to recognize the Republic of Cyprus as part of its EU membership process. Turkey's EU membership process, that is. So to conclude, there is no doubt that under Article 121 and customary law, Cyprus is entitled to full EEZ. This has been recognized by the US, the EU, and the other members of the international community, who in various ways have called on Turkey to avoid actions that cause tensions. More particularly, the Cyprus EEZ is clearly defined by model delimitation agreements with Egypt, Lebanon, and Israel, as I have already said. Turkey's claims are unfounded, but if Turkey so decides, can be pursued by negotiations as Cyprus and others have proposed. In the meanwhile, Turkey drills illegally and piratically in the Cyprus EEZ. Cyprus does not have the military means to prevent it, but it clearly has international law on its side, as I have tried to demonstrate. Thank you for your attention, and I would be glad to answer any questions.
Thank you, Mr. Ambassador. And if I might ask Nick Karambelas, if you can please take the map off the screen, please. Thank you. We'll now go to some questions of which we have from some of our viewers and others. Let me begin with what just transpired and sort of following the ambassador's comments. In July 13th, just 2 days ago, the Council of the EU Foreign Affairs Council meeting met and stated, and I quote, "It was stressed that Turkey's unilateral actions, in particular in the Eastern Mediterranean, which run counter to UN interests, to the sovereign rights of EU member states and to international law, must come to an end." That's all well and fine. And Mr. Ambassador, you mentioned under international law, you have Cyprus certainly has every right to everything we're speaking of here today to explore in terms of its EEZ. But in the real world, it still comes to how you can defend your rights. And words sometimes are just not enough, as we see time and time again. The Yavuz and other ships coming into Cyprus's EEZ, and there's nothing fundamentally that Cyprus can do in terms of on its own, because it doesn't have the military wherewithal to be able to move these ships out and to chase them out. So at the end of the day, while all this talk is good, while international law is something we should all live by and abide by, the reality still exists. So and the United States certainly has come out and has also stated that Cyprus has every right, and we recognize that Cyprus has every right to explore in its exclusive economic zone. But again, the realities are such. So what more can we do if this continues to go unabated, or it goes into another step and it escalates even more than what it is now, and it certainly has the potential to do so?
Well, legally, of course, all disputes under the UN Charter need to be solved by peaceful means. It's Article 2, Paragraph 3 and Article 33 of the Charter. So, as I said, legally, this is so, and if it is not complied with, and if the situation gets out of hand by having a military confrontation, the Security Council is available and has the appropriate jurisdiction to deal with the matter. Of course, this is more theoretical than real, as we have seen in so many other situations, including by the very fact that Cyprus is still being occupied 46 years later, despite Security Council and General Assembly resolutions. So this is the one part of what can be done. The other part, more practical perhaps, is through alliances and associations with neighboring countries. Of course, Greece is willing to assist, but of course they have their own situation with Turkey, as you know. Other countries, for instance, France has recently sent ships to demonstrate its interest. In fact, this was pointed out by the French ambassador at the reception of the French government 2 days ago in Cyprus. That was quite interesting that she went out of her way to say so. Israel could assist, perhaps. Egypt is in a position to assist, perhaps. But in practical terms, this is more hopeful than realistic. The United States has, of course, as you know, the Sixth Fleet in the region. And when it came to ExxonMobil drilling in Block 10, there was no interference by the Turkish Navy. It so happens that Block 10 is not one of those which are being claimed by Turkey as part of its continental shelf. So the answer to your question is what I have unfortunately said before, that Cyprus is in no position to use military means to defend itself, but it has international law on its side, and it also can and has resorted to the EU, which has made some declarations supporting Cyprus and calling on Turkey not to carry out these illegal acts which cause tension. But in terms of real action, we are still waiting to see it happen. It may happen. Some minor steps have been taken. 2 individuals have been put under sanctions. 2 Turkish individuals associated with the drillings have been put under sanctions, but that is, of course, not enough.
Thank you, Mr. Ambassador. Nick, I'd like you to, answer comment on that as well. But in addition to that, within the context of your reply, if you can also tell us, we have a question by Ambassador Patrick Theros, who states, can you explain why the Senate has refused to ratify UNCLOS, and how does that affect U.S. policy towards the current controversy, if at all?
Well, the first part of the question is actually the Senate's only real problem with UNCLOS is one of the articles that the ambassador mentioned, where there is a dispute resolution mechanism in the Law of the Sea Treaty to which nations can resort if they can't agree on their exclusive economic zones because they overlap. The treaty contemplates nations where the 200-mile zones overlap, that they're going to sit and negotiate and reach it. And that's what's happened in many parts of the world. But then if they can't, then they would go to judicial settlement or arbitration. And there is such a body set up in UNCLOS. Well, that's the part, the main part of it that the Senate disputes and does not want the United States to be subject to any international judicial or arbitral body at all. What's ironic, Mr. Ambassador, is that the United States has EEZ disputes. We have one with Canada and we have one with Mexico. Well, in the one with Canada, our position is, well, there are special circumstances that should be taken into account when you're delimiting the EEZ. on the Mexico-California dispute, the United States position is, oh no, it's the median line. So you can see that, you know, in a sense, the declaration and demarcation of EEZs is in the first instance a political act, then becomes a legal act. As to the second part of your question, how do we resolve these things? You know, I kind of rely on what the ambassador said, that, you know, we have to rely on law. And let me stress that when we say that, now I know the obvious response is, okay, well, you know, there's no court, mandatory court that you have to go to, so what good is it? Remember this, every act, international act, no matter how horrendous, was always grounded in law by the perpetrators. Hitler's invasion of Poland in 1939, he didn't just cross the border. He established first, put German soldiers in Polish uniforms and had them attack a German radar station at a place called Gleiwitz and several other points along the border, and say, oh, well, that's why we're invading Poland. I mean, even though it's ridiculous, and it's just as ridiculous, Turkey's positions, they're still he felt obligated to ground it in law.
Except he didn't feel it that way as he continued to go through Europe.
No, but in the first instance, because he didn't know that the French and the British weren't going to fight.
Mr. Ambassador, you have a...
Yes, may I add something to my friend Patrick Theros asked? During the conference, and I was there most of the time, there were a number of issues that the United States under President Reagan found not to its liking, including the Seabed Authority and the exploitation of they didn't want to socialize the oceans, that was the expression. Subsequently, so the United States did not sign the convention in 1982. However, subsequently, there have been a number of changes made with US cooperation to this regime of the high seas, which satisfied the United States administration under President Clinton. And President Clinton signed it, and subsequently, there were a number of efforts to get it through the United States Senate. In fact, when Hillary Clinton was Secretary of State, it went through and was approved by the Senate Foreign Relations Committee. However, when it came to the Senate as a whole, you need 2/3, as you know, to get a treaty through. And 33 senators became on record and declared that they would not accept it for the reason that Nick mentioned. So that's where the situation is. The United States, in practical terms, accepts most of the provisions of the convention as customary law. It has applied even the median line vis-a-vis the Bahamas, vis-a-vis Cuba, and generally accepts the provisions of the convention, but it falls short of ratification because of the reason I said.
Thank you, Mr. Ambassador. Moving along, Mr. Ambassador, you have a fan who's watching here today, Professor Ted Kariotis, who also in his own right has been a prolific writer and advocate regarding the EEZ, and he extends his congratulations and says how honored he was to work with you and be with you at the United Nations Conference of the Law of the Sea. He has a question regarding Castellorizo, which I'll tie it into another question, and we are going to have a more full discussion on Greece and its EEZ and other maritime boundaries, but it is worth bringing into the discussion at this point regarding the fact that, you know, in January, Greece, Cyprus, and Israel announced a collective effort to build a pipeline to carry out hydrocarbons from Israel through Cyprus's EEZ and through the EEZ available to Greece onto Europe. The question of how this will happen, of course, is dependent, though, on the status of Castellorizo and the EEZ that surrounds Castellorizo and its adjacent islands. playing a little bit of a devil's advocate here, even though both of you have declared, within the context of the law, that islands absolutely do have EEZs, there seems to be, as there always seems to be under international law, always this ambiguity sometimes as it relates to certain aspects, as has been proven into some other, was it Taiwan, Nick, or one of those countries out there in Asia, where a ruling came down against a specific island, to my recollection. So I guess at the end of the day, Costa Lorenzo and adjacent islands are very critical to uniting both the Greek and Cypriot EEZs to further advance this projected pipeline.
Nick, may I put up a map that will show that issue?
Please.
Yeah. Mr. Ambassador, please let me know if I'm saying this correctly. Just Costa Lorenzo, it's actually 3 islands, very small, maybe 500 people, outside of summer. Okay, it's located right here. So here's Rhodes, here's Crete, and it's located right here. Well, if you give Costa Lorenzo an EEZ to which it is entitled of 200 miles because islands are, you see that its EEZ extends down to here, near almost to Egypt's. So that means that the Cyprus EEZ would connect to this EEZ available to Greece. Greece has not declared an EEZ, certainly not in this area. It has in Italy, that's a separate matter. But you can see that the pipeline would then go here, well, probably to Cyprus, Israel, Cyprus, and through this to the Greek EEZ when declared, and then on to Europe.
Is there any question whatsoever that Turkey claims that Costa Lorenzo has no bearing to EEZ, has no legal rights to an EEZ?
Mr. Ambassador?
Yes, this is a little complicated. In terms of entitlement to the zones of maritime jurisdiction, as already pointed out by Nick, in other words, Continental Shelf, Exclusive Economic Zone, Territorial Sea, Contiguous Zone, there is no question that under Article 121, Paragraph 2, Costa Lorenzo as an inhabited island, it may have 500 people now. It used to have a lot more. And in any case, it is an inhabited island, and so is Strongili and Rho, which are part of the complex of Costa Lorenzo. In terms of entitlement, there is no question that they should be treated the same way as other land territory, which means full effect of, for purposes of exclusive economic zone. Now, there is this other article, however, in the law of the Sea Convention in UNCLOS, Articles 74 and 83, 74 for the EEZ and 83 for the Continental Shelf. And there, even though we tried during the conference very hard to have the median line accepted as the rule, this was, after many debates, not fully accepted. There was a rather formula which is rather ambiguous, which was introduced by the president of the conference so as to not to have to vote on the issue, which provides that in cases of delimitation of states which are opposite each other, as Costa Lorenzo and Turkey are, the question should be solved by agreement in accordance with international law, as in Article 38 of the statute of the court, so as to achieve an equitable result. Now, the equitable result is a subjective term, and one could argue that equity requires that Costa Lorenzo not have full effect. I don't think we should go to court if we go to court, if Greece goes to court on a position other than that in Article 121.2. In other words, full effect. It may well be that a court might consider the circumstances and decide that equity should be otherwise. But in the meanwhile, the Greek position is valid, that full effect goes with castellorism. And in practical terms, in the judicial instances so far on kinds of delimitation, the tribunal invariably starts with a median line and then it goes up or down, varies the median line, depending on the circumstances. So at least that much is there for those who are for the median line, as we are, Cyprus is and Greece is. And this is what should be, I think, in my opinion, the case with castellorism. I agree with Ted Kariotis, whom I have a lot of respect for. He's one of the most knowledgeable people in international law. And he had a debate with Mr. Rozakis, Professor Rozakis some years ago, in which he won by overwhelming majority on this very point.
So again, because a lot of the people on are not legal experts, it is unambiguous to you, Mr. Ambassador, that absolutely, you know, castellorism has rights of the EEZ, and absolutely that will unite Greece and Cyprus's EEZ, and you have absolutely no ambiguity on that.
I have no ambiguity in terms of what it ought to be, this position. Whether it will be in a court of law, I am not so sure.
Well, there you go. Well, but it really is up to Turkey ultimately to be able to take that to the court. Greece should not, but Turkey, if it wants to, let Turkey take it. Is that what you're saying?
Yes, yes, yes.
Okay. All right, fair enough on that. We have time for a few more questions. Going back to the overall Cyprus issue and the discussions for unification, how does Turkey's maritime claims against Cyprus EEZ affect the decades-old settlement discussions to reunify the island?
I don't think it should affect it. As I said, there is no way in which the Turkish Cypriot community, or the TRNC as they call themselves, has the right to dictate what should be the policy in the Cyprus EEZ reserves. This belongs to in every country in the world, belongs to the recognized government of the recognized state. The Turkish Republic of Northern Cyprus is neither a state nor recognized as such. It is a community, however, and as a community, they are entitled as Cypriot citizens, as I already said in my statement, to the equal rights which all Cypriot citizens should have. And there have even been proposals which go beyond that to allocate to the Turkish Cypriot community a certain percentage, 20, 25, 30% of the resources of the EEZ as a way of solving this problem. So far, this has not been accepted. In any case, there is no way that it can be that the Turkish Republic of Northern Cyprus should have equal voice as the government of Cyprus, or should be able to grant licenses to Turkey to explore.
Nick Karambelas, we see United States coming out against China's in the South China Sea, and again, although it claims regarding the rights of Cyprus to explore its EEZ, it doesn't seem, in my opinion, and please address this if you in your comments, hard enough as relates to Turkey as it does to China. Would you say there's a double standard here?
Well, we're talking about international situations, and to the logical mind, of course, it's a double standard. It's beyond a double standard. It's hypocrisy. But the line that we will always get back from the government is, well, you have to deal with different circumstances in different parts of the world. Okay, to me, that undermines the credibility of international law, especially when we're talking about a law that is so comprehensive and so accepted throughout the world, like UNCLOS. in the end, it's credibility in these kinds of treaties that matters. And I should also note that, you know, there's a position that the executive takes with law of the sea issues, and a position that Congress does. I mean, Congress has inserted itself into our foreign policy pretty much, you know, continuously since the Vietnam War. And AHI has, over the years, briefed congressmen, senators, issued briefs, reports, drafted sample legislation, and much of it has been accepted, but not implemented. You know, those are the sorts of things that certainly our founder, Gene Rosides, started from July 20th, 1974, and what we continue to do as an organization.
Well, certainly the arsenal for democracy in 2020 should be the rule of law and international law, but unfortunately that's not always the practical situation. Mr. Ambassador, you wanted to add something?
On the question of China, as some of you may know, there has been a case by a special tribunal set up in The Hague, which in 2016, after a full discussion, reached a conclusion, which I think is the right conclusion, that the Chinese claims of historic title, the 9-dash line, and to use water rocks as distinct from islands as islands was not well-founded. So there has been in the news, in fact, even today, there was a big piece in the New York Times on the question of the Chinese-US relations in the context of the South China Sea. And I think this is a relevant factor to bear in mind.
Allow me one last question, gentlemen, and within the context of your answer to this question, please also incorporate your final comments as well, because we are now past the appointed hour. Look, it's no surprise what we have seen in terms of the aggressive behavior by President Erdogan of Turkey, especially within the last 6 months, but certainly within the last year and a half. So from the increase in violations regarding Greece's territorial integrity by maritime infringements and air violations, obviously in Cyprus, the Yavuz seems to go back and forth like it's a ferry boat that goes between Turkey and Cyprus, and it's there again once again, as I believe yesterday. Not to the blue homeland doctrine of Erdogan, which has raised the specter of the dangerous actions of Turkey in the Eastern Mediterranean, and finally seems to have gotten the attention a little of the Europeans, and I would hope also regarding our friends here in the United States and others. Where do you see all this going? There's no supposed to be any abatement on behalf of Mr. Erdogan or what shoe might drop next. And I'm not so sure anymore, as once upon a time, maybe the president can pick up the phone here in the United States, as Clinton did with the EMEA, or as Johnson did in '64. Where are we going here? And how much of a real danger do we feel regarding the issues in the Eastern Mediterranean? And even though it's become very dangerous in terms of these actions, it's also, as I said, raised a little bit more of the consciousness of the littoral states in the region and of the EU. Your comments, please.
Well, Nick, I think it's time everyone concluded that it's no longer a question of trying to conform Erdogan's behavior or Turkey's behavior in any way. He has an agenda that is a religious nationalist agenda. Greece and Cyprus are obstacles to this agenda. And so I think it's really more a question of dealing with him on that level rather than hoping he's going to come to conform his behavior to some kind of Morgenthau, Kissinger type of context.
I agree entirely. And of course, Erdogan is not only he's a neo-Ottoman. He wants the resurrection in many ways of the Ottoman Empire. We've seen his actions not only in Cyprus, but also in Syria repeatedly, and in Iraq, and currently in Libya. So evidently Turkey under Erdogan wants to establish itself as the hegemon of the region. And this is very unfortunate, but we've seen this time and again, and he doesn't listen to anybody. So happens that he has a good relationship with the current president of the United States, and I think his son-in-law has a relationship with the son-in-law of the president of the United States, which may affect some actions. But on the whole, I think that the United States has taken a correct position on the Cyprus situation. In fact, we didn't touch on the East Med, which was mentioned earlier, which would be Israeli gas and perhaps some Cyprus gas to find its way through a pipeline to Crete and Greece and Europe. That's a huge project which has many practical difficulties, but it's doable. And so that's another step which the United States would support, for one thing, because it would make Europe less dependent on Russian gas.
Well, we're going to have to leave it at that, gentlemen. But here at the American Hellenic Institute, which our mandate is to help to promote and strengthen U.S. relations with Greece and Cyprus, as within the context of the best interest of the United States, we submit that the region needs to be peace and stable for the United States to be able to project its image and its interest in that region. And there are countries that are helping to provide peace and stability. Greece and Cyprus, and of course the relationship that exists with Israel is at the top of the list in providing for that peace and stability. And as we've proven here once again today, it's still countries like Turkey that continues to provide for that instability. And unfortunately, it could get worse before it gets better. And we need to keep our eye on the ball and continue to press our policymakers and others to make sure that they're paying attention to the region and have with a better understanding of what the consequences could be if it continues to go during this path. As always, I'd like to thank our two guests here today for their invaluable expertise in presenting a complicated matter. It's still, even to me, I still find it a little bit difficult sometimes in terms of understanding the complexities as it relates to the continental shelf in particular. But be it as it may, these are issues that are going to be coming continuously down the road as energy becomes important to the development and for alternative resources of energy for Europe other than Russia. So we will continue to keep monitoring this and make other presentations as warranted down the road. But again, I thank our speakers. As always, I'd like to thank our staff here at the American Hellenic Institute, Yola Pakchanian, Elias Yerasudis, who does a lot of our research, Emily Pantis, who acts as our producer for these Zoom presentations, and a lot of good work that's being done. And I want to mention them by our current interns remotely from their two locations, Vasily Ioannidis and Anthony Katsounis. And I'd like to remind our viewers that we will have one more presentation in July, and this one will be next Wednesday, but at an earlier time from 10:30 to 12, where typically the American Hellenic Institute every year does a commemoration regarding the illegal invasion of Cyprus by Turkey in '74. We do it on Capitol Hill in conjunction with the Congressional Hellenic Caucus. But for this year, obviously, we are not able to be on the Hill. So we're going to conduct it in a Zoom platform. And we have at least 10 members of Congress so far who have committed to be present that day. And we hope to get a few others. And we hope that you will tune in at that time. In the meantime, I always got to remember our audience that the American Hellenic Institute is a nonprofit organization, and we are highly dependent on your support through donations and memberships. So please go to our website, ahiworld.org, and please consider becoming a member and a supporter of the Institute. Until next time, I'd like to thank all our listeners and our guests here once again, and wish one and all a very good afternoon. Thank you, ladies and gentlemen.
Thank you, Nick.
Thank you, Nick.
Thank you.